All right, so I want to start with an administrative thing, which is that a few folks have mentioned that they've had issues entering the PIN for attendance, and that because there's internet problems in the building, and I'm sympathetic to that because I too have had internet problems in the building, but I'm not going to sort of adjudicate who has a valid excuse for not entering the PIN and who doesn't. But here is what I will say. It usually takes me a little while to go into D2L and mark the folks who didn't enter the PIN as absent. And it is not an honor code violation for you to write down the PIN and enter it later. So the honor code violation is if you write down the PIN and then you go and you give it to somebody who wasn't in class. Okay? So I say that just to sort of, give you guys an opportunity to deal with technical issues without sort of me having to go, okay, this person has a valid issue and this person does not. So like I don't want to get bogged down in that particular game. All right. With that, so last time we left off, right, we had just reached the point where we've discovered in discussing the Erie Doctrine that essential characteristics of federal courts cannot be overridden by state law under the Erie Doctrine, right? So Byrd is looking at the jury guarantee of the Seventh Amendment. And then now we're going to move forward into, the court does not describe it in this way, but I would say that we're looking at other ways in which essential characteristics are preserved and the reasons why they become essential characteristics. So with that, Mr. Summers, if you could help us with just the first part of DRQ 40, what two conditions must be satisfied before an Erie choice of law issue can arise?
That there's diversity jurisdiction to bring it to federal court, and that there's a conflicting federal and state rule.
Okay. Is it only diversity jurisdiction?
No, but that it would be in a federal court, I guess.
But what other source of jurisdiction would give rise to a state law claim being heard in federal court? So a federal question would not be a state law claim, right? It would be a federal law claim. So what other sources of jurisdiction would give rise to a state law claim? Mr. Morgan, you saw your hand raised. Right. Okay. So back to you, Mr. Summers. In Hannah, how are these two conditions satisfied? By the way, you were right about the second condition, right? The conflict between the state and federal law. So how were those two conditions met in Hannah?
There was diversity jurisdiction.
Right.
And that it was a question whether it was the federal rule about service to the defendant or if it was the state rule for service to the defendant.
What was the difference between the rules?
Well, one, it could be handed to a person like a spouse, like in the house of the person in the federal rule, and in the state rule, it specifically had to be put in the hand of the person being served.
Exactly right. Okay, so I have nothing to add here. We have successfully pulled out all the pieces, right? So we're correct that there's only two sources of jurisdiction that matter for the Erie Doctrine, 1331 and 1367, and that there has to be a conflict between the state and federal rule. And think back, remember, to our discussion of guarantee trust, that if there is no conflict between the state and federal rule, it doesn't really matter which rule you use. And so my reading of guarantee trust is that where there's no conflict, courts should use the federal rule because that's what they're familiar with. I think you can just as easily read guarantee trust to say that where there's no conflict, you should use the state rule because the state rule is the one that should control. So again, with respect to Hannah, you are correct, Mr. Summers. The basis of jurisdiction is diversity, 1331, and you've correctly described the alleged conflict right? That under Massachusetts law, there is a requirement to actually put the complaint in the hands of the defendant in order to properly serve them, while the federal rules of civil procedure provide for a number of other types of service, the relevant one in this case being serving at the defendant's residence with a person of appropriate age. Okay? So thank you, Mr. Summers. Ms. Kearns, so why precisely does the trial court grant summary judgment for the defendant in this case? And so there's some discussion in the concurrence in Hannah about a case called Reagan, and I think that that case may be instructive in giving you some grip on the trial court's decision. I'm sorry. You're speaking very quickly, and you're just running it together enough. I can't quite understand you. So speak up a little bit and slow down.
So for the Reagan case, it held that for the purpose of the Kansas statute of limitations, the receipt tort action commenced only when service was made upon the defendant. And so here, because of when the statute of limitations started, there was such an inadequacy of service, so they held it was done.
So does Hannah have to do with the statute of limitations specifically?
No.
So Reagan has to do with the statute of limitations, right? Has to do with when the statute of limitations gets told. Okay. So what was the federal rule in Reagan?
The federal one allows the depository service.
In Reagan, was that the rule?
Federal 1 3 provides that an action commences with the filing of the complaint filing the complaint.
Right. So the statute of limitations is told upon filing. And what was the Kansas rule in Reagan? You said it a minute ago.
When service is made on the defendant.
Right. Statute of limitations is told when the defendant is served with the complaint. Okay. So just out of curiosity, right, let's assume, because I don't know what the rule was when Reagan was decided, but let's assume that we're dealing with this situation today. And so does anyone know under Rule 4 how long you have to serve a defendant after filing a complaint? Don't look it up. If you don't know it, I'll just tell you. But does anybody know it off the top of their head? Yeah? Mm-mm. Nope. Nope. It's 120 days and can be extended for good cause shown. Okay? So basically, right, the difference in this rule, assuming that this time period is the same, and it's not, it's been extended over the 80 some odd years we've been dealing with the rules of civil procedure. But assuming that that time period was the same, that's a period of 4 months where a federal lawsuit would be told, but a state lawsuit would not. Okay? So, Ms. Kearns, back to you. Still in Reagan, okay? Which rule did the Supreme Court say to apply? Right, the state rule, okay? And so, following Reagan, what did the trial court in Hannah rule?
I'm not exactly sure why.
Well, okay. Let us assume that the trial court was faithfully following Supreme Court precedent in Reagan. What logic would Reagan suggest that would lead to a ruling for the defendant in Hannah? Why? And so under what circumstances would you apply the state rule following Reagan? What's the circumstance that Reagan creates? Okay, let me ask the question a different way and see if maybe that helps. Okay. What is the source of the federal law in Reagan? The rules of civil procedure, right? Which rule? Rule 3, exactly right. Okay. And what is the source of the state law in Reagan? It's a state statute, right? There's some, it may be a rule of court, but in Kansas, those are promulgated as statutes, right? So what is the conflict between in Reagan? On the one hand, we have what are the two things that are in conflict here? And okay, so now in Hannah, what are the things that are in conflict? And so you should do what if you're following Reagan? Right. Okay. So this is exactly what we find when we look at Hannah's characterization of the district court's opinion, right? And I do want to note, there's this comment in the concurrence that whether your state law claim is valid under the Reagan rule, right, is not in your hands. It's in the hands of your process server, which maybe you're comfortable with that. I don't know that I am, but like that's choice. Okay, thank you, Ms. Kearns. Mr. Brown, why does the First Circuit Court of Appeals affirm the district court in Massachusetts?
They kind of quote the legislative history of personal notification, and that they found that there was a conflict between state and federal rules of substance rather than a procedure.
I think that's right. So is that the same grounds?
It's similar, yeah, but a little bit different.
I mean, so I guess let me come back to here, right? So if this is the logic of the trial court, and I am purporting to you that it is, where does the substantive procedural divide come into play in this logic? Okay, point me to the word substantive.
It's not in there, but it can be inferred, I feel like.
How?
I think it's following the Erie jurisprudence, and kind of that jurisprudence seems to deal with substance. So when there's a conflict, they usually deal with it with substance.
So you're right, that we are, that anything that we're doing in this choice of law space implies an interest in whether something is substantive or procedural. But, right, we have to look at what is the analysis we're being given. Okay? And so, where is the substantive rule?
There is none.
Certainly not according to the trial court. Okay? So the trial court doesn't seem to be interested in the substantive procedural divide. And remember what we talked about, right, that after guarantee trust, we had these two tests for choice of law. We had the substance procedure test, and then we also had the outcome determinative test, and we had courts that weren't really being very clear about which test they were using, right? And the two tests are sort of running in parallel. So you are correct that the First Circuit ruled that the Massachusetts rule in this case, right, the service in hand rule, was substantive. And you are correct that they reached this conclusion by drawing on the legislative history of the recent amendments to the statute. However, the point I want to make with this is that this is an example of what we call whole record review, where courts of appeals can affirm on any ground that is apparent from the record. Okay? Even if the issue that they choose to affirm on, not brought to them by the parties, and even if the issue that the parties do want to litigate, the lower court got wrong. As long as the ultimate decision was correct for some reason, the Court of Appeals can affirm. So, okay. Let's see. Mr. Vasquez, what was the defendant's argument to the Supreme Court? And let's work through, in discussing this, sort of the Reagan case and the York case that the court talks about.
The defendant's argument was that Erie has made clear and guaranteed trust in New York versus New York v. York and Reagan v. Merchants Transfer Warehouse demanded that federal courts apply state law whenever the application of federal law will alter the outcome of the case.
Yeah. So now let's apply that to this case, right? So what's the outcome if we apply Massachusetts law?
So here, the defendant argued that if Massachusetts service requirements were applied, he would immediately prevail, while applying Rule 4D1 would probably lead to a different outcome.
Probably or possibly? I think that's probably right. And the reason I want to make that distinction is that the defendant's argument, right, isn't that he does lose if the federal service rule is applied. It's that the lawsuit continues and he could lose. And he says that's enough of a difference in outcome to require the application of state law under the rule in York. And he says that Reagan applies this same logic even if the federal law is a rule of civil procedure. Okay? So, thank you, Mr. Vasquez. Ms. Borgading, so we've just worked through the defendant's argument in Hannah. What's the argument that the Supreme Court uses to conclude that that argument is invalid?
Yeah, so the Supreme Court refers to the application of York as a litmus paper test. And so I put that the outcome determining test and guarantee trust is not a magical test that solves all problems just by looking at one singular factor.
Yeah, so let me ask you guys this. Do you guys remember from high school chemistry, or maybe college chemistry, what a litmus paper is? Ms. Morrissey, you look like you say maybe. What is your recollection of a litmus paper?
I'm getting it confused with like the carbon transfer.
Fair enough. So, fair enough. Litmus paper is what is used to test unknown fluids for their pH. Okay? So are they acidic? Are they basic? And the idea is that litmus paper is a tool that allows you to test the entire spectrum of pH using one tool. And you sort of read it. It changes color, and you read the pH of the substance by looking at the color that it produces. So that metaphor, I think, is useful in that the court is saying that this is not like a magic bullet, right? And there's a different metaphor. This is not a one-stop shop. There's a third metaphor for resolving conflicts of laws, right? We are not dealing with just a one check the box and then we move on with our lives, okay? So, Ms. Borgerding, let me ask you this, because I think you're right for the most part. Is the Supreme Court as an institution, and in this case, but also more generally, is the Supreme Court only concerned with the results in the case before it?
No, they're concerned about the precedent as well.
Right. And so let's assume, for the sake of argument, that the court were to adopt the defendant's proposed rule. What limiting principle can we discern from the defendant's argument? Like, is there a boundary where we would feel comfortable saying the defendant's rule applies to cases on this side of the boundary and not on cases on the other side of the boundary? So, I think what I'm trying to ask you is, the initial condition for an Erie analysis requires a conflict between the federal and state law. The defendant's reading of the rule says that if the change in outcome is that we have to keep litigating, that's enough of a change in outcome for me to win, right? Even though the rule in question is at least arguably procedural, right? So the defendant's argument is it's substantive because I still have to keep litigating, right? That I still have to keep fighting over the substantive rights. So my question to you is, can you think of a case where there would be a conflict like the one in Hannah, but where the defendant would agree that we should apply federal law? I mean, the short answer is it would be one where applying federal law helped them. But you can't say that in court, right? You can't sort of openly admit that you are unprincipled and all you care about is winning, even if it's true. So is there a principled test that we can use? And I'll let you off the hook and sort of throw this out to all of you. Is there a principled test that we can apply where we can adopt the defendant's rule but still have some scope for using federal procedural law in state law claims? Mr. Brown, you've given me the east-west nod. Can you help me with why? You're right. I'm going to tell you, you're right. Can you tell me why?
Anytime the federal rules of civil procedure would be in conflict with a state rule or state statute, you'd always apply the state statute. You could always make an argument that the outcome could change based on that. So either way, like you said, you can make an argument that goes either way. So I feel like it would be just a no.
No, you're exactly right, right? If a given procedural variation, and if a given procedural variation is the key turning point in your case, then that variation is outcome determinative, right? And so under the defendant's rule, we essentially wipe out federal procedural law. And just to sort of like give you a couple of examples of like some of the problems that would cause, right? The federal rules under Rule 6 and Rule 16 provide for various scheduling mechanisms and timing mechanisms. But state courts frequently use different timing mechanisms and sometimes don't have timing mechanisms at all. So federal, Rule 16 mandates that federal courts enter scheduling orders for civil cases. In the states that I practiced, Rule 16 orders were optional, and lots of judges didn't enter them. Even if you asked for them, they would go, no, we'll just let the case run. But then the other piece that sort of puzzles me is federal courts can consolidate claims, right? This is what we were talking about earlier with the joinder rules. They can consolidate claims that arise under federal law and that arise under diversity or supplemental jurisdiction, right? That's the whole point of supplemental jurisdiction. So does that mean that we have to apply federal procedural law to arising under claims and state procedural law to state law claims? So in case you were wondering, right, all of this is sort of by way of saying that the defendant's rule leads to an absurd result. And so that is why the court rejects it, okay? So let me sort of shift gears a little bit here. Ms. Jackson, I want to think back to Byrd for a second, right, to what we discussed on Wednesday. Did the court in Byrd rely solely on the outcome determinative test? You're right. No, you're right. Okay. So what did the court in Byrd say about outcome determination? Right? So let's sort of roll it back and think back, right? So what was the rule that was in conflict in Byrd? Mr. Albertini, what was the rule that was in conflict in Byrd?
Was that the one where the jury would hear the affirmative defense or the judge would make a decision?
Right. Okay. And did the court think that who decided that issue would lead to a different outcome?
They said that it very well could.
Right. It sort of presumed that that was reasonable. Okay. Did the state law rule get applied in Byrd?
Initially it did, I think, through the trial.
Did the Supreme Court say that we should apply the state law rule?
No.
Right. Okay. So what we have in Byrd is actually a command that outcome determination does not end the analysis. Right? So even if the defendant is correct that they win under an outcome determination analysis, Byrd has told us that there's more to the story. Okay? And so what we can conclude from Hanna and Byrd is that the federal rules of civil procedure constitute an essential characteristic that cannot be altered by state law. Okay? So I just have one last question, right? let's say that what I have just said is correct, that the rules of civil procedure are an essential characteristic of the federal courts. So what the hell happened in Reagan? So let's unpack that and sort of take it step by step. So, Ms. Schulte, was there a conflict in Reagan between a state law and an FRCP? And which rule won at the Supreme Court? And so if I've just told you that the FRCP is an essential characteristic of the federal courts, how did Reagan come out like that? That seems inconsistent with Reagan. So what happened? Let me preface this by saying, like, there's a right answer here, but it's not one that you sort of should feel like you have immediately at hand. So.
Was it because they hadn't decided it was essential characteristic?
I mean, that's sort of a very cynical answer that is probably correct. Let us suppose that that we are shifting away from the positivist approach, and we're moving back in the direction of, well, things that are correct now have sort of always been correct. So what does the court offer us as an attempt to distinguish Reagan?
Well, didn't the concurrence just say that he thought it was wrong?
I mean, yes, but the court, like the majority, actually does make an attempt to distinguish these two cases and to explain why they come out in opposite ways. Okay, can somebody help us out? Yeah, Ms. Jackson, and then Mr. Huerter, you can take a stab at it.
I feel like in Reagan it was more substantive. Like it was a rule that I don't know. It was a rule that I guess decided how a substantive issue would operate. I guess I don't know how to describe it better, but like using a different rule, I don't know. It applied to a substantive law, I guess.
So, Ms. Huerter, I'll let you take a stab at it before I sort of tell you what's going on.
Was it because are they saying Reagan should have never gotten to that essential characteristic analysis because of the federal interest?
I don't think so. So what happens in Hanna, and the majority, I think, the issue for the majority is they don't want to acknowledge Reagan explicitly, because then they have to grapple with the fact that these seem to be pointing in different directions. So they kind of talk about it obliquely. Here's what they say, right? It is true that there have been cases where this court has held applicable a state rule in the face of an argument that the situation was governed by one of the federal rules. But the holding of each such case was not that Erie commanded displacement of a federal rule by an inconsistent state rule, but rather that the scope of the federal rule was not as broad as the losing party urged, and therefore, there being no federal rule which covered the point in dispute, Erie commanded the enforcement of state law. And so, I think I would phrase this argument a little differently. You can kind of see how I phrased it here. But the rule in Reagan, which is when does the statute of limitations get told? Is it upon filing or upon service? that rule doesn't actually exist in Rule 3. It exists in the advisory committee notes. And so I think if I wanted to, I think probably the concurrence has the best argument of Reagan was wrongly decided, wipe out Reagan. But if I'm in the majority and I don't want to explicitly overrule Reagan, I think the stronger argument is to say that the advisory committee notes are just persuasive interpretations of the rule. They aren't the rule itself. And so there is, in fact, no conflict with a rule of civil procedure because we don't have to follow the advisory committee notes. You can be persuaded by that or not. It's fine either way, but that's what I have to offer. So, okay. Questions so far? Yes, Mr. Brown.
Is the inverse true with all these rules? So if a state is hearing a federal rule, is it basically the same that the state procedural rules apply?
So that is what's referred to as the reverse Erie doctrine, right? So state courts hearing federal law claims. And what we are not going to cover reverse Erie in this class. And in fact, I haven't looked at it since my 1L civil procedure class, which was 4 years ago. But my recollection is that you are correct that state courts hearing federal law claims apply federal substantive law and state procedural law. But, don't quote me on that because it's been a long time. And it's not something that's going to matter for you guys, at least not in this class. So, okay? Does that help? Okay. Any other questions? Okay. So, moving on. Let's see. Mr. Devon, how does Hannah modify the outcome determinative test that we've initially seen in Guarantee Trust, right? So I've given you an excerpt from the opinion that is sort of relevant to this question, but it's also in your book, so you had it in front of you when you were answering this question. So what do you have for me?
So basically, when it's a matter of procedure, if there's a federal rule on point, that applies to the state. And if there's not a federal rule on point, then the outcome, like the Erie test would apply.
So what I would say is that you have correctly identified the rule that the Hannah court announces and applies, but you have not answered the question. Because this question is specifically asking, how does Hannah change the outcome determinative test? And nowhere in your answer did I hear outcome determinative, right? So, but you're right in what you said, it just isn't responsive to this question, okay? Mr. Johnson, can you help us with this question?
Yeah, I said it raises the burden. It makes it so the outcome has to be substantially altered by using federal law over state.
At what point does it have to substantially alter the outcome?
Start.
Right. It has to be a change in outcome that we can predict at the time of filing, right? So what Hannah does to the outcome determinative test is it asks you to inhabit the mind of the plaintiff at the time of filing, okay? We do this all the time in law. We try and put ourselves in the minds of someone else, and we almost never talk about what it means that we do this. But this is something that Hannah wants you to do, right? And so you are to assume, under Hannah's formulation of the outcome determinative test, that the plaintiff is aware of the difference in law between the two fora that is sort of relevant for deciding the case. Okay, so in the particular sense of Hannah, it's the difference in forms of service. Would that difference affect the filing choice of the plaintiff? Okay? And if the answer is yes, then you apply state law. Okay? Mr. Weens, I'm going to ask you to work through this process step by step for Hannah itself.
So, the serving forms per law
Mhm.
don't really change. Like they apply later. Like at the start, they would have both allowed the plaintiff to bring the suit.
Right. If the plaintiff had known that the Massachusetts service rule would apply and not the federal service rule, how would she have changed her behavior? Well, she would have served the lawsuit faster, right? So maybe she would have hired a different process server, not go through the marshals, right? Whatever. But whether she files in federal or state court is not going to be determined by how she has to serve the defendant, right? Exactly right, okay? So we ask ourselves, at the time of filing, would knowing which rule applies have changed your behavior? And if the answer is no, then we don't have to apply state law, okay? Now, Mr. Devon, back to you, and I think you're going to understand why. Is the Supreme Court's modification of the outcome determinative test in Hannah dispositive of the result reached in that case?
Yes.
Okay, assume you said no. Now tell me why.
Okay. I was going to say because Massachusetts law, if it is used in or if it was used, the litigation would not have.
Let me ask a different question. What's the rule that the court actually announces in Hannah?
Was it the?
You just said it a minute ago.
Okay. Basically, if there's a federal rule, then it should apply.
Specifically a federal rule of procedure, then it applies, right? So again, right? Following the Hannah outcome determinative analysis, we cannot have an outcome determination, right? So we can't use that to determine the rule, okay? So Mr. Devon is correct that the clear congressional command is to apply the federal rules of civil procedure in all cases and all claims, okay? In order to go against that command, the court says that you have to conclude that all of the institutions that were responsible for promulgating the rules of civil procedure, that's going to be Congress, that's going to be the Supreme Court, that's going to be the Advisory Committee on Civil Rules, all of them were wrong about the scope of authority that they wielded. So, okay. Mr. Devon, I'm going to come back to you. So, does the Hannah opinion create an entirely separate test to decide whether state or federal law should apply when a federal court is adjudicating a state law claim and the federal law conflicting with state law is a federal rule of civil procedure?
Yes.
And what is the test?
I mean, is it basically just if it's an issue of federal, or if it's an issue of procedure, then the federal or civil procedure would apply?
As long as it's valid. Now, what I will tell you is if you find yourself arguing that a rule of civil procedure is invalid to try and get yourself into a more favorable state law situation, you should expect to lose because I am aware of 0 cases where a federal procedural rule has been held to be invalid. If you find one, I'd be very interested in hearing about it, but I am not aware of any. Okay? All right. Mr. Devon, you're off the hook. Thank you for your assistance. Ms. Coolidge, when the Supreme Court refers to a relatively unguided Erie choice, what does that even mean?
I just kind of went back to the basic of saying the court here is kind of reminding courts of the power of the federal court.
In what sense?
I think it's kind of reminding them out there that the federal, we have a clear federal procedure at that point.
Well, okay, so let me pull you in a different direction, because I think that what has happened is you've answered this question focusing on sort of what the court is saying this isn't, right? So the court is saying that where we have a federal rule of civil procedure, we do not engage in the relatively unguided Erie choice, right? So that implies that when the federal law in question is not a federal rule of civil procedure, we do engage in a relatively unguided Erie choice. So the question, the DRQ is asking you, what is that relatively unguided Erie choice?
I would say in situations then that we don't have a clear federal procedure.
Right, but then what do we do?
And then we look to compare, I guess, what we do in the federal courts versus, like, at that point, we move into these tests.
Which tests?
The test we just quote.
Which Hannah, because Hannah gives us 2 tests, remember? Right, so which one? Okay, somebody help us out? Hannah gives us 2 tests. Which one do we want? Which one is the relatively unguided Erie choice? Okay, what does it say isn't the relatively unguided Erie choice, right? This is what the court actually says. So it should require no thought, just read. Ms. Kellum, do you have it? We've sort of wandered afield, so I saw you look at the slide. The question that I'm putting to you is, what is the thing that the court says does not involve the relatively unguided Erie choice? Okay. Ms. Akins?
The one is covered by federal law.
Okay, right. Which means, what's the alternative? What's the other test that Hannah gives us? The outcome determinative test, right? So this is what we've, like, the relatively unguided Erie choice is all the stuff we've already done. That's it. That's it. It is not that complicated, right? The court is literally telling you that when there's no rule of procedure, then your job is to do the stuff we've already told you to do. Okay? All right. Now, this is the hard question of the day. Mr. Morgan, this is the hard question, and I have confidence that you can handle it. explain why the Hanna Court concludes when a situation is covered by one of the federal rules, the question facing the court is a far cry from the typical, relatively unguided Erie choice. And the book gives you several extracts from the opinion. I have not reproduced them on this slide, but you're welcome to refer to them.
I am not confident in my answer, to be honest.
Well, do you?
Rambling on my answer.
So,
I said, which I don't think is right, but federal courts are supreme to state law when augmented by the necessary and proper clause and or otherwise enforced by valid congressional statutes.
I think you're on to something there, but I think there's some missing pieces, right? So let's think back to our discussion about the nature of American federalism, okay? So what is the trade-off between the federal and state governments under American federalism? Think back. If it helps, we discussed this with DRQ 29 for this chapter, if you need to go back and look. So here, I'll just give it to you, right? So federal government only has certain powers, but when it acts within those powers, everything it does gives, controls. State governments exercise all the powers that sovereigns have under common law, but if they are acting in a space where the federal government has validly exercised power, state power must give way. Okay? So, let's sort of break this down step by step. So, coming back to our question, right? When a situation is covered by one of the federal rules. So, when a situation is covered by one of the federal rules, Mr. Morgan, what is the enumerated congressional authority that is being exercised?
Can you repeat the question?
When we are dealing with a federal rule, what is the source of the congressional authority that leads to the existence of that rule? Yeah, what is the source of the federal power to create federal rules?
Is it one of the articles?
It is one of the articles, yes. Federal power derives from the articles of the Constitution. Excellent first step. So can somebody else help us maybe narrow it down beyond the articles of the Constitution? Yeah, Ms. Boardney. Which is an exercise of what congressional power? Right. Okay. Absolutely right. Okay. So Article 3 provides that inferior courts are ordained and established by Congress. If you think back to McCulloch in Con Law 1, the power to create implies a power to preserve. There's also a 1989 case that discusses this related to the Sentencing Commission, Mistretta versus United States. I've posted an extract of that opinion on D2L. It is not necessary for you to go and read it, but it may help clarify some of this. And so the power to create inferior courts implies the authority to define the scope of those courts' power, right? So this is what you were talking about when you mentioned the necessary and proper clause, right? So that authority can also be delegated, and that's where Mistretta comes in, because Mistretta is about delegation of congressional authority. And so the rules are presumed to be valid. Okay, so we've just got a minute left, so I'll just give you the rest, right? When you have a conflict between a federal rule of civil procedure and a state law, you have a conflict that is conceptually at the same level, right? You have two congressional enactments that are directing you to an answer to the question of what law controls. Which means that the courts are required